But what if they called their daughter Retina Display Cutter or Chicken McNuggets Cutter? Would that be any different? My name is Andrei Mincov. I'm the founder of Trademark Factory. And in this video, I'm going to share my thoughts about yet another trademarking screw up. This time around, it's the trademark opposition over the name Blue Ivy Carter, raised by Beyonce. But before I read the article, as I usually do, let me just say something. There's this legal maxim, something that lawyers love to say, and it goes like this: bad facts create bad law. And what it means is that some hard cases where judges need to deal with really unfortunate circumstances, unfortunate consequences, sometimes judges come up with decisions that create rules that don't really work except for those extreme cases. And this dispute, this opposition actually shows that it could be one of those examples where bad facts will create bad law. So let's just go through this one step at a time and you'll see exactly what I mean. Blue Ivy Carter called a cultural icon in Beyonce's battle over name trademark. Okay, so Beyonce is ringing the alarm on this argument. The name of the star's 7-year-old daughter, Blue Ivy Carter, is at the center of an ongoing trademark battle. According to a brief newly filed by attorneys for the singer's limited liability company and obtained by E-News, in January 2016, the company filed an application to register a trademark for Blue Ivy Carter, which would cover goods including fragrances, cosmetics, skincare, baby teething rings, playing cards, and more. However, in May 2017, a woman named Veronica Morales filed an opposition against the trademark, citing her own trademark Blue Ivy, which she had applied for in 2012. Blue Ivy is the name of Morales' Boston-based lifestyle event planning firm. Actually, before I move forward with the article, let me just show you the filings because this is where the whole thing started to unravel. This is where the bad facts were created. So if we do the search for Blue Ivy, there's a bunch of trademarks here. Most of them are dead, some of them are live, but here are the relevant ones. Here is the first trademark application filed by Beyonce's company, right? BGK Trademark Holdings, LLC, right? So they filed their trademark for Blue Ivy Carter on January 26th, 2012. Now, this is extremely important. January 26th, 2012. And they filed their trademark for a bunch of stuff. So fragrances, DVDs, metal keychains, baby teething rings. So all of the stuff that's mentioned in the article and more, and a lot more. All of these classes, all of these goods and services, right? So they filed their trademark in 2012, but not just 2012, January 26th. Remember the date because that's important. Now then, this woman, Veronica Morales, files her trademark on February 8th, 2012. So a couple of weeks after. And her trademark is Blue Ivy for event planning and management for marketing, consultation in the field of special event planning. And so she files her trademark a little after. And just so we know, the daughter was born on January 7th, 2012. So they give birth to the girl. They name her Blue Ivy Carter. And shortly after, they file their trademark, right? They file their trademark, like I said, January 26th, so 19 days after she was born. And then Veronica files her trademark 2 weeks after that. Now, the problem for Beyonce is that when their trademark was allowed, they had to show use. So in the US, your trademark won't get registered unless you submit what's called a statement of use, showing to the trademarks office that you're already using the mark. And if you don't do that, you can request several extensions of time, each for 6 months, but there's a limited number of those extensions. So when they ran out of possible extensions of time, the Trademarks Office said, yeah, we're gonna kill this application. It's now dead, it's now abandoned because you failed to file the specimen and the statement of use. Too bad, so sad. And when that happened, Veronica's trademark was actually registered long before they ran into those problems. It was one of the faster ones, right? So filed in February and registered in October, and it just flew by, no problems, right? So she filed, and then she renewed this recently in January. So that's good. And here is what else they did. So Beyonce's company then filed a new trademark on January 22nd, 2016. So let's look at it again, because the dates are crucially important here. Their trademark was deemed abandoned. The first trademark they filed was deemed abandoned in February 22nd, 2016. And so what they did is, a month before then, they filed a new trademark. This is a usual rule. So it's a common strategy. You file a trademark, and if you're not using the mark and not even planning to start using the mark really soon, you keep requesting extensions of time, and then when you realize that you ran out of them, you file a new trademark application for exactly the same thing, and the old application dies, and then you'll have the new application in the system, and so you expect to be able to do this again and again and again until that time when you actually can show that you're using the mark. Problem with that, or the risk in that, is what if somebody files the same trademark after you file your first application and before you file the second one? Because what's happening in that moment is when your first application dies, somebody else's application becomes first in line. And so your second application becomes second in line. And with trademarks, it's a big deal because you always want to be the first in line. So this is exactly what happened here, except there is always this argument that the marks are different enough, because when Veronica filed her trademark, she did not get any objections from the Trademarks Office that her trademark, her goods and services, are too close to a previously filed application by Beyonce's company. And surprisingly, they're not really making that argument, but we're going to go through that in a moment. But so her trademark goes through, and now Beyonce filed their new trademark. It also goes through the Trademarks Office system. The Trademarks Office system doesn't have a problem with that, but then Veronica finds lawyers to go after Beyonce and opposes their mark. Okay, so that's the situation. They're now in opposition. Veronica really doesn't want them to register their trademark, and they really want to register that trademark. So let's keep going. The opposition, which claims that consumers are likely to be confused between a boutique wedding event planning business. So Veronica Morales runs a event planning business. So the opposition, which claims that consumers are likely to be confused between that boutique wedding event planning business and Blue Ivy Carter, the daughter of two of the most famous performers in the world, is frivolous and should be refused in its entirety, the brief states. So it's not journalism, it's actual quote from the response from the brief from the defendant's brief in the opposition, right? About two of the most famous performers in the world. Opposer has demonstrated repeatedly that it's not at all concerned about how the presence of the Blue Ivy Carter trademark in the marketplace will impact its own Blue Ivy trademark. Rather, Opposer has exhibited a pattern and practice of affirmatively attempting to connect its brand with Blue Ivy Carter to increase its exposure and DRUMEO business. As an example, the brief points to a radio interview Morales participated in which she discussed the inquiries the company had gotten after Blue was born. Okay. In the brief, Beyonce's attorneys further argue that trademarks differ thanks to the inclusion of Blue's last name, Carter, and that there is no likelihood of confusion between the two trademarks given one is the name of a celebrity and the other one is not. Okay, well, this brings me back to, can you name your child Retina Display Carter and say, well, her first name is Retina, her last name, her middle name is Display, and her last name is Carter, and say, well, because we added Carter to the trademark, now we should be able to own the name. It's a very iffy argument, if I can say so. So the BGK mark brings to mind a famous child who is listed in the IMDb database reported on by Popular Press and whose name generates millions of hits on a Google search. The brief reads, the commercial impression of a poser's mark is not a human being. Instead, it's commercial impression of an event planning business. Due to this drastic difference in connotations and commercial impressions, there's no likelihood of confusion between a poser's mark and BGK's mark. Also contends that a poser could not plausibly argue that someone searching for help with planning a wedding, a reunion, or other social or business gathering will somehow instead stumble upon a famous celebrity's brand and confuse BGK's mark with a poser's mark. The brief declares Blue Ivy's trademark is a cultural icon who has been described as a mini-style star and has been celebrated for her fashion moments over the years. Her life and activities are followed extensively by the media and the public. So the documents also explain the context of Blue Ivy Carter trademark filing. So Blue Ivy Carter has achieved a significant amount of fame, particularly at such a young age. She also has a noted and well-chronicled interest in fashion. The brief points out, and given these factors, Blue Ivy Carter is capable of and interested in becoming the face of a brand. For this reason, the factual context demonstrates that BGK filed the application with the intent to build a brand around Blue Ivy Carter and her public reputation and renown. Beyonce's company has requested that the Trademark Trial and Appeal Board dismiss the opposition and allow their trademark for the Blue Ivy Carter trademark to move forward to registration. Okay, so that's the article. Pretty good summary. But what I wanted to do is quickly walk you through the legal paperwork. And unlike some of the other videos that I did, this is going to be really brief. So don't worry. Here's what's happened. It's actually the second video that I do on this topic, but there's been some development and I want to share them with you. So here's what the opposer, Veronica's lawyers, filed. A 217-page brief. And don't worry, we're not going to go through 217 pages. There's a couple of things they do. And let me just show you the... Actually, let's start with table of contents, because that's probably most of what we need. There's, the procedural stuff, blah, 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 the recitation of the facts, and here's the argument. Basically, they say a couple of things. So first thing they say is that a poser has standing to oppose applicant's application. And what that means is that they're saying that Veronica has the legal right to oppose their trademark. And the reason they're bringing it up is because Beyonce's lawyer is saying that Veronica does not have standing to do that. Second thing they say is that Blue Ivy Carter should not be registered because the applicant did not have a good faith intention to use the mark at the time of filing. And they also say that it shouldn't be trademarked, it shouldn't be registered because it's likely to cause confusion with Blue Ivy mark, and also because the Beyonce and her company committed fraud on USPTO. All right, so they go through all sorts of things here, but I'm just going to go through the bad faith, the fraud argument. So give me a second. Yeah, so here's the fraud. Here's what they're alleging. They're saying that it's fraudulent because they never had intent to use the mark in connection with goods and services listed in the trademark application. And when you make a declaration that's knowingly untrue, it could be considered fraud. And they're citing an interview reported by Vanity Fair that there was a question posed to Jay-Z about why they filed this trademark, and he said people wanted to make products based on our child's name, and you don't want anybody trying to benefit off your baby's name. It wasn't for us to do anything. As you see, we haven't done anything. And basically what Veronica is saying is that if your only goal is to prevent others from using a brand that you have no intention of using yourself, it's not a proper filing, it's fraud on USPTO, because when you file your trademark application, you have to declare that you have a genuine intention, good faith intention to use that brand for the products and services that you've listed. So that's the setup. If we also go through what Jay-Z's lawyers have responded, again, they say that there's no standing. They say that there's no likelihood of confusion because marks are different in appearance, sound, and connotation. They say that goods and services are not related. They say that goods and services will be marketed and sold through different channels of trade. And they say that the opposer's mark is not a strong or famous mark, which reduces the risk of likelihood of confusion. And then they say that they have a good faith intent to use the mark at the time of filing the application, and that there was no fraud on the USPTO. So there's a lot of back and forth going on here. The one thing I'm going to go through here is the standing part. You can always find these documents online, just the way I did, but I'm just going to go through a little excerpt from here. So, right, so Beyonce says, opposition must be dismissed because opposer lacks standing. And they say that the only way to oppose, the only person who can oppose is a person who believes that he would be damaged by the registration of a mark. They say that Veronica did not show any reason why she would be damaged by them registering their trademark. It's not a great argument, but if they succeed, that's really the end of the opposition. So they have to make it because it's a low-hanging fruit. Really what they're saying is she's not being damaged by our trademark because we're doing something different things, but it's not entirely true, because if she owns Blue Ivy and they go in and have Blue Ivy Carter, it does two things to her trademark. First, it limits the scope to which she could expand her brand. And second, it dilutes her brand. So these are somewhat overlapping, but they're actually different, because one says, it would be harder for her to start adding products and adding services to what she already does under that name Blue Ivy, because Blue Ivy Carter would be registered. The second thing about the dilution basically says that the value of her own brand goes down because there are other players with a similar brand. Now, I don't think, like I said, that Beyonce is going to win that argument, because the threshold is relatively low there. But there's a lot of other arguments, a lot of other things going on here. So when Veronica says that they did not have a good faith intention to use the mark, that would probably be true for the first trademark, for the first one that they filed in 2012. It's not necessarily true in 2016. By that time, they already probably knew what it's going to be used for. Now they're in this opposition and, butting heads. But really, there's only two parties that are going to win anything with this dispute. Can you guess what they are? Veronica's lawyers and Beyonce's lawyers. Nobody else is getting anything out of this. Well, maybe the journalists who now have a reason to write something about Beyonce and this dispute. Because beyond that, Veronica is certainly not winning anything. Beyonce is certainly not winning anything, well, other than publicity. It's like I said, it's bad facts create bad law. Because here's what we got. Again, remember, Beyonce files first, then Veronica files, then Beyonce files again, then Veronica opposes. And now they're fighting. They're at the point when they've spent so much money. I can understand how Beyonce can find the money to pay their lawyers. With Veronica, I don't know if it's pro bono, the lawyer just wants to make a name on that, or they're actually making Veronica pay. I don't know. What I do know is that oppositions are extremely expensive, and to have a brief of 217 pages, it's not a walk in the park for a small event planning business. So I'm curious what the arrangement is, because it really doesn't make any sense. This whole dispute, this whole opposition makes absolutely no freaking sense. There's truth to a lot of what Beyonce's lawyers say. They say, look, well, I don't buy the argument about Eddie Carter and that making the marks very different. But they have a great argument about the goods and services not being anything close, right? They're not running an event planning business. They're not educating people about building events. Because if you look at Veronica's trademark, that's not Veronica's trademark. Where's Veronica's trademark? If you look at Veronica's trademark, you'll see that what she got it registered for is for event planning and management for marketing, branding, promoting, or advertising the goods and services of others, special event planning for commercial, blah, 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 online retail store services featuring paintings, wedding portraits and invitations, personal management services, blah, 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 and consultation in the field of special event planning for social entertainment purposes, special event planning for social entertainment purposes, party and wedding planning for coordinations. Okay, so what should have happened in this case is they should have long time ago settled. They should have long time ago find a way to resolve this. They should have long time ago find a way to either coexist, which would result in a coexistence agreement whereby Beyonce would promise to Veronica not to expand to certain areas, and Veronica would promise not to go to certain areas, and Veronica would allow Beyonce to register their trademark for the things they want, maybe get paid something, probably get paid something, maybe even paid a lot, but that would have put an end to everything. And the other option would be for Beyonce's company to just buy out the name from Veronica, plain and simple, right? Outright. And that's another viable option, whereby the wedding event company would get some money, change the name to something else, and be done with it. And especially since, as the defendant's brief says, the brand is owned in connection with the daughter of two most influential, most famous entertainers today. I'm sure they could make Veronica an offer that she wouldn't be able to refuse. And instead, what's happening is that Veronica is spending money on lawyers who attack Beyonce, and probably that's the expectation, that they're going to get paid. But again, Beyonce is not having any of that. But it just makes absolutely no sense. This whole thing, this whole dispute makes absolutely no sense, because it's going to cost both parties a lot of money, and it would have one of the two outcomes. The first outcome would be that Veronica is going to lose, and that would happen. My prediction is, if Beyonce's lawyers can prove that there's no overlap in goods and services, maybe they will remove some goods and services from the application and get that registered for most of those goods and services anyway, or somehow they're going to lose, and then what, right? So to the extent that Blue Ivy Carter becomes really noticeable as a brand herself, that's her name, right? As weird as the name is, it's a name, it's her official name, and nobody would be able to stop her from using that name, so that's an interesting thing. And again, going back to what if she was called Retina Display Carter, right? Would she be able to have that trademarked? And we could play around with bad facts all day long, and there's really no good answer to this. So we'll keep monitoring it. It would be an interesting case if it actually goes to hearing, if it actually goes all the way without settlement. It would be very interesting to see what's happening there and how far the parties are going to take it, because now they're both lawyered up. Let's say opposition reaches a certain conclusion. Well, guess what's going to happen? The losing party is going to appeal that, and it's going to go to the court system, and they're going to go over and over again. So lawyers are going to make a killing on both parties, and I'm sure they're going to have lots of fun doing that. Now, I hope you found this video useful and interesting. If you did, great. Make sure you subscribe to get notified whenever the next video goes live. We post videos like this every single day, so there's always something you can learn about branding, about entrepreneurship, and about trademarks. And if you've got a brand that you want to protect, if you're at the point when you realize that you're serious about your business and about your brand, and you're sick and tired of spending your time and money building a brand that's not even yours, because if you haven't trademarked your brand, it means you're building a brand that you don't own, a brand that you can't protect, a brand that you can't monetize, a brand that can be taken away from you like this. If you are ready to have a conversation about protecting your brand, go to trademarkfactory.com and book your free call with our strategy advisors, and they'll help you get things started. And until then, I will see you in the next video.